So thank you so much. It's really an honor to be here. The League of Women Voters is, obviously, I am a New Rochelle resident. I am a member of the League, a very proud member. I was actually on national television this weekend, and I said to a commentator that I think the League should take over debates again, and his head almost spun, and he said, well, we could do those just as well. And I said, no, you can't. So I am a very proud member of the League, and it is an honor to be here as the first speaker for the Edith Corbin Memorial Inaugural Lecture. And it's really a delight to meet Mr. and Mrs. Corbin, and I thank you so much for this. And of course, my dear neighbor, Peter Korn, former city manager. Everybody knows Peter. It's really an honor, and I thank him so much for all his help. When we first started talking about this, we planned to do it today because, as my students know, and my great students, so many of them are here on a Tuesday night when they really have other things to be doing. So thank you guys and gals. It's Constitution Day today, and it hasn't been widely celebrated in the press. The Census Bureau has been sending out emails like mad to get people to celebrate. So it's a very, very important day for me. And we always celebrate it. In fact, I had several alums email me and text me today and say, Happy Constitution Day. That's how much of a geek I am. So excited that it's Constitution Day. And obviously, it's also an election year. And so we wanted to talk a little bit today about voting, the Voting Rights Act, the famous Shelby case, and my view on voting rights in the country today. As you've been paying attention to the primary on the Democratic side getting going, there hasn't been a lot, there's been a little, but not a lot of discussion of voting. I, of course, think there should be more. But I also bring to this discussion a slightly different take. And I hope that you'll come with me on that. One thing I told Peter is I have a book coming out in a few months from Palgrave, and much of this discussion stems from that. And I was very excited because in doing some research on the League and Edith Corbin, I realized that Iona has this book that was published by the League called Seeds of Failure, which is where the title of this talk came from. And it's a political review of New York State's 1967 Constitutional Convention. And as some of you know, obviously this was at a time when Edith Corbin was very active in the League. New York is one of several states that allows for constitutional conventions or con-cons to reconsider the constitution of the state and make sure that any flaws that are inherent in it are adjusted or discussed, that there's a public conversation. 67 was the last one. And what I'm going to suggest tonight is that maybe we should consider something similar at the federal level. And that is a very controversial statement to make. I do not make it lightly, and I know particularly my liberal friends, their heads start to spin because you never know who will attend a constitutional convention. But I will make my case as bravely as I can. And to that point, I just want to read to you a quote from Thomas Jefferson in 1816, where he said, "Some men look at constitutions with sanctimonious reverence and deem them like the Ark of Covenant, too sacred to be touched. And as I hope we will come around to at the end of this talk, these are human constructs. They were flawed from the very beginning. As we know, women, not allowed to vote. African Americans, not allowed to vote. Slaves, not freed, right? And those are some of the flaws we talk about. I would suggest that there are many others. And I truly revere the work the framers did on the Constitution. But I also think it's worth discussing the flaws. And so when I talk about the Voting Rights Act, I do want to come back to what I see as some of the flaws in the Constitution. So on that point, let me just say very quickly, I'll walk you through as fast as I can from the founding through the passage of the Voting Rights Act in 1965, just to put this in context. As you know, when the framers were deciding to found the nation, they wanted to create a democracy. Their options were a direct democracy or a Republican democracy. We got a Republican form of democracy, the first real one, with one minor exception in human history. And that's, of course, why voting in elections are so important, because we live in a Republican, small r, or a representative democracy, where in order for the system to work, we have to have fair, free, and transparent elections. And so the root of the importance of elections goes obviously right back to the founding. And voting in early American history, at the Constitutional Convention, the framers had an option. They could decide to put in place a federal control of the voting and elections, but of course the states already had control of elections. And as in many other instances, they decided to leave the states primarily in control of elections. And hence some of the controversies that have erupted over American history concerning elections, with states wanting to maintain that power and the federal government slowly getting into the business of increasing control over voting and elections in this country. At the founding, there was obviously discrimination occurring when it came to voting. It was on a state-by-state basis, so it differed. But as I just mentioned, women did not have the right to vote. African Americans did not have the right to vote. In some states, people were discriminated against on the basis of religion or on the basis of class. So discrimination was rampant in early American history when it came to voting. And it's not until the Civil War era that the federal government begins to move into the arena of controlling or having a say or a voice in voting. And that, of course, occurs first as it pertains to the 14th and 15th Amendment, the two of the three Civil War amendments. And so, as all of my students know, the 14th Amendment is always the most important amendment in the Constitution, bar none. Everybody likes to talk about the first, but or some people like to talk about the second these days, but it's really the 14th Amendment, because it's the 14th Amendment that restricts the states. And when you think about who is going to have the biggest impact on your rights and in your life on a daily basis, it's going to be the state and local governments, not the federal government. And so while the first 10 amendments are very important in the Bill of Rights, they speak solely to the federal government. And it's not until the passage of the 14th, and those of you who remember back to basic American government, or if you went to law school, the incorporation that ensues from the late 1800s through the Second Amendment in the 2000s, that whole history is the history of trying to make sure the states are required to follow the Bill of Rights, and that happens because of the 14th Amendment. So the 14th Amendment is one of the Civil War amendments. It's critical, and it's in this case, when you're talking about voting, it's critical because it speaks to equal protection of the laws. And so in this case, as you can see here, the clause is, no state shall deny to any person equal protection of the law. And a couple things to note there. It's speaking specifically to states, not to individuals, not to the federal government, not to other entities. It's speaking to states. And it's making the case that you cannot deny any person. That's not just slaves, that's anybody. And you can't deny them the equal protection of the law, which is the states cannot discriminate against people. Now, as with everything in the Constitution, you should say, but wait, states discriminate all the time. Governments, by design, discriminate. That's what they do, right? And so there are legal constitutional discriminations that we are all fine with. For instance, those of you who may have applied to a state school and not gotten in, that's a form of discrimination that we say, that's okay, right? We're okay with that. You can apply and be admitted or rejected from a state university. That's discrimination that we think is constitutional. But there are other forms of discrimination that are not constitutional. And so the court has, over the years, created a variety of tests to determine what is and what is not constitutional. And any time you are talking about a suspect class, a race, for instance, and the state wants to discriminate on that basis, or gender, or age, then the court is going to take a stricter look at what the state is trying to do. It's going to be harder for the state to discriminate in those cases. So when we talk about the Equal Protection Clause, we're talking about discrimination that is outlawed or unconstitutional. And of course, the 14th Amendment is not our only voting amendment. We get the 15th Amendment, which denies states the right to discriminate in voting on the basis of race. The 19th Amendment, which allows women the right to vote, right? The 26th Amendment, which allows people 18 years of age or older, critical during the Vietnam War as young men were being sent to fight and die for a war that they could not vote for. That became a critically important issue. So there's been several since the passage of the 14th and 15th Amendment voting amendments to the Constitution. All of them speak to the states. All of them tell the states that they can't discriminate. And all of them, importantly, give Congress the ability to pass legislation to ensure that right. So in the case of the 15th Amendment, the states cannot discriminate on the basis of race. And the Congress, the federal Congress, is given the right to pass legislation to ensure that that right is abided by. And that's a critical part of this story. So we have several amendments to the Constitution that come up. But of course, as you know, following the Civil War, we have a short period during Reconstruction in which there are a few pieces of federal legislation passed to ensure voting. But very, very quickly, Jim Crow goes into effect, and the southern states begin to deny voting on the basis of race, using things like poll taxes and literacy tests and those kinds of tactics, including things like straight-out intimidation. And the result is dramatic in terms of the impact on voting for African Americans, particularly, although not exclusively, in the South, where they are the numbers drop dramatically in the 10 years after the Civil War and continue to drop precipitously through the Civil War era, through the Civil Rights, era. And so that is a dramatic story. The outcome of that is, of course, an activist movement. And, of course, this is Martin Luther King, and along with several other famous civil rights heroes marching, and the famous Selma March for voting rights. And it's these kinds of activist activities which encourage the federal government, including a president from Texas, Lyndon B. Johnson, and the legislature, to finally pass and push for the Voting Rights Act of 1965. The Voting Rights Act of 1965 is one that many people describe as the most important and most successful piece of federal legislation ever passed in American history. Now, whether you agree with that or not, because you may have your own favorite pieces of federal law, it was remarkably successful in changing voting in states that were discriminating at the time. And obviously that's a picture of Lyndon B. Johnson signing the piece of legislation. The legislation is complicated, but let me just point to you two things that become critical as we move into the 2000s. And that is Section 4, the coverage formula, and Section 5, which is pre-clearance. So what they did when they passed the law, and it's obviously a big piece of legislation, what they did is they said it's not going to cover the entire country, but it's going to cover states, subdivisions, counties that have discriminated in the past. And that's what we describe as the coverage formula. So you don't need to know the formula itself, but they came up with a formula based in 1964 that said if you do not meet this requirement and you have discriminated in 64, you will be covered under this act. And by being covered, that meant that if you went to change a voting or election law in the country, in your state or division, you had to seek approval, which is the pre-clearance. You had to seek approval by the federal government to do that, right? So again, all that means is if you were covered by the law, you had discriminated in 64, or your registration population was not up to par, you were covered. That meant you had to seek approval for any changes to voting and election laws that you made. Whether you wanted to change where people were voting, how people were voting, put in voter ID, whatever you wanted to do, you had to seek approval from the federal government. And the idea there was, of course, if you were forced to seek approval, if you sought to do something that was racist, where you were discriminating against people on the basis of race, you would be stopped. So those are two really important parts of the law. And of course, the impact of the voting rights law is dramatic. So if you look, for instance, at these statistics, you can see these are southern states, several, about 13 in all, and you can see the increase in voter registration from the period before it's passed to the period after it's passed. And in almost every case, the numbers go up. If you look at an even more dramatic picture, these are black legislatures in the South from 1868 to 1900. And you can see the drop there to 1900, 0 African Americans elected in these southern states. You look at the statistics following the Voting Rights Act passage, and the numbers go up dramatically. And in fact, by 2010, I believe, we are close to 15,000 African American elected officials in the South. So the impact, when you look at the number of African Americans elected, is dramatic. And this is, again, one of the reasons that people say this law was so incredibly effective and important in securing the right to vote for African Americans and securing African American politicians and people who wanted to run for office to be able to be active in their districts. This law was obviously challenged many, many times, and I won't go through all the challenges, but the Voting Rights Act has been challenged from the day it was passed. The most famous early case was Katzenbach. He was the Attorney General under Johnson, and in this case, the state of South Carolina challenged the law. They wanted the Supreme Court to stop Katzenbach from enforcing the law, and they had a really significant case, which was that if you read the Constitution, Article 1 in particular, it says that voting rights are under the purview and control of the states, and all of a sudden we have a piece of legislation that has handed that power over to the federal government. And it was ripe for a contest between the federal government and the states, which South Carolina carried forward. The Supreme Court took this case on original jurisdiction, which if you know about the court, they almost never do. That's how important it was. And in an 8-1 decision under Chief Justice Earl Warren, they sided with the Voting Rights Act and they upheld it. And what they said, amongst other things, you could see that's a big quote from the decision. He said that Congress, in passing the law, felt itself confronted by an insidious and pervasive evil, which was race used as a basis for discrimination in voting in the South. And as a result, they concluded that unsuccessful remedies, which it had prescribed in the past, would have to be replaced by a sterner and more elaborate measure, and that measure was the Voting Rights Act. It was an 8-1 decision. Justice Black did dissent in part, but only because he thought that the legislation itself could have been changed slightly. So it stood the test under Katzenbach. Several other challenges to the Voting Rights Act in the 20th century. In most cases, the Supreme Court was upholding the Voting Rights Act, and you could see some of those listed in Harper. They abolished poll taxes in Oregon. They outlawed literacy tests. But as you get into the 21st century, things start to change. And one of the key examples I will give you of the change is something that all of us, I'm sure here, lived through and remember well, was the election in 2008 of Barack Obama, the first African-American president. That election, as those of you who are old enough to remember it, was often described as an election which ensured that we were in what? A post-racial America. That racism in all his forms had ended, and this was a significant sign of that, right? His election was sort of the mark of it, but there were other things that people would point to, including those statistics I showed you earlier. People who were African American were getting elected in the South in record numbers. Voter registration amongst African Americans was way up. In other words, the Voting Rights Act had succeeded. Barack Obama's election was followed closely by the 2010 midterm election, in which Republicans did very, very well. And they not only did well at the federal level, but they did well at the state level as well, and they took over many state houses. And in the context of doing that, and in the context of his election, there was a hue and cry to revisit the Voting Rights Act. And that is essentially what occurred. So to give you an example, in 2009, a small subdivision that was a part of Texas named the Northwest Austin Municipal Utility District Number 1 went to the Supreme Court, and it was cited against Eric Holder, the first African-American Attorney General. And what they had wanted to do was they had wanted to move their polling place in their small, it's a very small subdivision. They were covered under the Voting Rights Act because they're in Texas. They had no history of discrimination on the basis of race or anything else. They wanted to be let out of coverage. But in order to be uncovered and cleared to change their voting booth and place from a private house, if you can imagine, this is how small this place is, to a public school, they had to hire attorneys, and that would take most of their tax base to do it. And so they filed a suit saying this is crazy, essentially. We have no history of discrimination. We shouldn't have to use all our tax money to appeal to the federal government so we can make a change that has already been made in most areas of the country anyways. The Supreme Court did not strike down as they requested the Voting Rights Act, but Chief Justice Roberts did signal that he was very concerned about the Voting Rights Act at that time, particularly Sections 4 and 5. And that, coupled with Barack Obama's election and the 2010 election, really created a firestorm amongst attorney generals in many states that were covered, who started saying, we should not be subject to this act anymore. In 2006, Congress had renewed the act, but as opposed to revisiting the coverage formula, what they had done was what they had done, as opposed to revisiting the formula, they had renewed it for 25 years on the basis of a formula that they renewed in the 70s. So for that, all of those complicated reasons, in 2013, Shelby County, Alabama, went to the Supreme Court, once again against Eric Holder, and they challenged several aspects of the Voting Rights Act. Importantly, Section 4 and Section 5. The coverage formula, which was used to determine who was covered, and the pre-clearance formula, right? And in this case, and this is the big case in the voting rights arena, the Supreme Court issued a party line vote of 5-4, and those of you familiar with the justices can see you have Roberts writing the majority decision, and the majority is Scalia, Thomas, Kennedy, and Alito, and the four moderate to liberals in dissent, Ginsburg, Breyer, Sotomayor, and Kagan. Right? And what Chief Justice Roberts said is that they were going to overthrow or overturn Section 4, the coverage formula. And of course, once you overturn and say that coverage formula is unconstitutional, they didn't need to overturn Section 5 because there's nobody to clear if nobody's covered. So they essentially overturned the entire act. And you can see there a quote from Chief Justice Roberts' decision where he says, "There's no denying the conditions that originally justified these measures no longer characterize voting in the covered districts." In other words, his and the majority's problem was with the fact that when Congress renewed the legislation in 2006, they didn't revisit the coverage formula for places like the Northwest Austin subdivision or Shelby County, Alabama. They simply renewed it on the basis of discrimination that had occurred in the 60s and 70s. And his point was, times have changed. Congress has an obligation to not just renew these things haphazardly for 25 years, but take a real concerted look at it. Since they didn't do that, the 5 conservatives or moderate conservatives overturned the act in what became probably one of Ruth Bader Ginsburg's most famous dissents, and she is the author of several, as you know. She made this very famous statement that throwing out pre-clearance, which again is Section 4, when it has worked and is continuing to work to stop discriminatory changes, is like throwing away your umbrella in a rainstorm because you're not getting wet. And that is a very famous statement by Ruth Bader Ginsburg in that dissent. And you can take a moment to read it for yourself. Throwing out pre-clearance when it has worked is like throwing away your umbrella in a rainstorm because you are not getting wet. And it is an absolutely valid reflection of what the moderate liberals on the court and many people around the country were feeling about this decision in Shelby. And of course, you look at the impact of the Shelby decision, and as dramatic as the Voting Rights Act was in terms of its impact, the impact of the Shelby decision was equally important. Since 2010, but specifically 2013, when the act was overturned, half of the states in the country have passed and put into practice restrictive voting rights. And these are things like requiring a voter ID, removing the ability for people to engage in early voting, right? All kinds of restrictive measures. And this is from the Brennan Center, which does amazing work on voting. And this is a map that they have put together to show you the states that have passed these pieces of legislation. These include many of the formerly covered states and subdivisions that couldn't do anything without approval, who now were free to do whatever they wanted. And when I tell you they acted quickly, I cannot underscore that enough. Many people I know do not pay attention to Supreme Court decisions as they come out, but legislators in states affected by the Voting Rights Act were paying close attention to their decision in Shelby. And if we just use Texas as an example, and poor Texas always gets the negative examples, but it's justified in this case. In 2011, they had passed a very restrictive voter ID law. They didn't put it into effect because they couldn't, because they were still covered by Shelby. The minute, and I say the minute, the day the court overturned Shelby, they put this law into effect. And what this law says is that to vote, you need to have one of these forms of ID: a Texas driver's license, a Texas election identification certificate, an identification card. I'm going to skip that one for a moment because it's telling. A U.S. military identification card, U.S. citizen certificate, or a passport, or a concealed handgun license. What they refused to include there was a student ID, even student IDs that were given out by public institutions in Texas, including the University of Texas. So what you had there was a conservative state legislature trying to protect its power in the state by passing a law that made it difficult for people who they feared, particularly young people, may vote more Democratic. And so they passed a law to restrict that. And the impact was dramatic. If you look at the legislation that ensued and the court cases that ensued after this, you could see about 600,000 people were disenfranchised by this law. Most of them poor, most of them minorities, most of them young. And the stories are dramatic. This is, to give you an example, you would have a story of a woman who was born in Alabama but was moved to Texas as a child without a birth certificate, didn't drive, and now was in her 70s or 80s and had voted all along. They passed this law, and she was now required to go to Alabama to get a birth certificate so she could come back to Texas and get some form of ID. And she is not able to do that because of the cost. And that is a real person, I won't reveal her name, but is a real person in the court records, and there are many people like her who were disenfranchised by this law. And again, this is not to pick on Texas. They were one of 25 states, about 15 that engaged in the voter ID decisions, right? But this is the kind of thing that Shelby, the overturning of the Voting Rights Act in Shelby, opened up. And this is what has created a firestorm. Keep in mind that 2014 and 2018 were the first midterm elections since the Voting Act was overturned. 2014 had amongst the lowest turnouts in U.S. history since before World War II. It was up in 2018, in large part thanks to the president, because he got a lot of people who weren't voting before voting. 2016 was the first presidential election since the overturning of the Voting Rights Act. And 2020 will be the second because Congress has still not handled the situation 6 years later, right? So this is a little bit about the aftermath. And it's to Congress I want to turn next because I think there is a tendency often when we talk about the Shelby decision to talk about it in the context of a Supreme Court with a majority of conservatives who overreached in order to protect their own, the GOP, and who overturned the act to protect people who are conservative or Republican who are voting and to protect their own power. Whether you believe that or not is up to you. But I want to suggest the problem is, a bigger problem is at stake. And that is Congress. The court stepped in this case. And whether you agree with what they did with Shelby or not, the point that they made was actually fair on the majority side, which was that Congress needs to do its job. Congress cannot just be allowing the Voting Rights Act, renewed in 1972, to be renewed in 2006 without considering the coverage formula. That coverage formula impacted tons of people, including, by the way, in the state of New York. They had an obligation to look at that coverage formula, and they didn't. And voting is only one area in which Congress has abdicated its responsibilities, I would argue. Not long ago, the New York Times ran an editorial by Tim Wu. And those of you who are familiar with, or techies and like tech, he is the father of the notion of net neutrality. And Tim Wu is a law professor, and he was writing a piece in which he made a very important point, which is that we often hear in the media in particular, and God bless my friends in the media, they say this all the time. People are so divided in this country. Nobody agrees on anything. Can't find a consensus on anything. And it's a mantra we hear over and over and over again, and not just in the media, but elsewhere. And Tim Wu wrote a piece in which he said, if you actually look at the numbers, that's not the case. There is incredibly widespread agreement on sensible gun control, to name one example. There is incredibly widespread agreement on reducing the price of drugs and pharmaceuticals, which are ridiculously expensive for all of us, right? There is incredible agreement in this country on higher taxes for people in the wealthier classes. And you could go down the list. And when he went through the numbers, these were polls showing anywhere from 65 to 95% agreement, right? And his question was, with all this agreement, why has Congress not acted? And you could say the same thing about the Voting Rights Act. It was overturned in 2013. Whether you agree or not with what the Roberts Court did, they threw the ball back to Congress. It has been 6 years. There is legislation sitting there. They have not yet renewed the act or passed the act. Not even close, right? And I don't want to blame Congress because I think the problem is bigger than Congress. I'm not one of these people who likes to sit around and say, oh, politicians today, they all stink, public officials, they don't know what they're doing, they're self-interested. I don't believe that for a second. We have really, really good public officials in this country, and we have some who are not so good, as we know if you live in New York or Illinois. We have a few. But people are people. And I don't think the blame should ever fall on the individuals in office. And that is something that I will continue to say. We commonly, and the media is famous for this because the media likes to talk about individuals because they're more interesting, right? Oh, the president is this. Oh, the Senate Majority Leader is this. Oh, the House leader is this. The Speaker is this. Bad, bad, bad. Whatever they are working in a system. And if there's a problem with passing legislation over and over again in this country, it's probably not the blame of the individuals, but the system itself in which they're working. And that gets us back to the Constitution and the League in New York in 1967 and the Constitutional Convention of 1967. The Constitution as you know, was written by men who, number one, wanted to ensure against too much federal power. For good reason. They fought a war against a king they described as a tyrant. They certainly wanted to assure that they didn't write a constitution that gave them too much power, a little more than the Articles, but not too much. And they also wanted to ensure liberty, freedom from government. And for many of us who look at the Constitution like I do, they did their job and they did it extremely well. But they did it so well that it is very, very hard to get things done in the United States today. Even things of which there is widespread agreement on, like sensible gun control, right? Like decreasing the cost of pharmaceuticals, right? Like with the Zika virus, trying to get funding for that, which you couldn't find a person in a poll who disagreed with that, and yet they couldn't pass it for a while, right? I mean, there is trouble there, and it's not because of the people in office. It's because of a system that is so divided that getting things done is hard, and that's true again for the Voting Rights Act. It has been 6 years since the VRA was overturned. Congress has the ability with legislation on its desk to pass it, and it has still not done that. And so what I would argue is that, yes, you may agree or disagree with the majority in Shelby. You may agree or disagree with the dissent. But you also, well, not you, but we, I think, need to also look at Congress and the system that they're operating under, which is the Constitution, and have a real concerted conversation about the Constitution itself and the amount of division built within it. And oftentimes when you talk like this, people get very nervous that you are un-American, that somehow talking about the Constitution as in some ways or somehow flawed makes you un-American. And obviously it's something I reject. And this gets us back to the quote by Thomas Jefferson, where he said in this letter to Samuel Kercheval after he left office, that some men look at constitutions with sanctimonious reverence and deem them like the Ark of Covenant, too sacred to be touched. They ascribe to the men of the preceding age a wisdom more than human, and suppose what they did to be beyond amendment. Laws and institutions must go hand in hand with the progress of the human mind. With the change of circumstances, institutions must also advance. And there is room to advance our Constitution, and there are ways to do that. In writing the Constitution, they made amending it very, very difficult, right? They made holding a constitutional convention very difficult, and for good reason. But there are ways to have this conversation, and you do, by the way, have people out there having this conversation. Another example I would give you is Woodrow Wilson. If you are in political science, you know we always like Woodrow Wilson because he was only president who was also a political scientist. But he said the Constitution is not honored by blind worship. And I think that that is very, very true. And so many states, like New York, have an ability for voters to call for a constitutional convention. They don't happen often, and they're, as we know, not always or almost always successful, but they do allow for a conversation to be had. There are challenges to constitutional conventions, and I would argue that I am the first person to say I worry about a runaway constitution and all those kinds of convention and all those kinds of things. But there are things you could do short of amending the Constitution to diminish these divisions. And let me just give you one example. Those of you who are old enough to remember Lloyd Cutler, who worked for President Carter, wrote a very famous piece in which he addressed a very similar problem in the I think it was the late 70s, 80s by the time he wrote it. And he argued for things like potentially the president choosing a portion of his cabinet from the Senate, potentially tying the electoral futures of the president and the Senate and members of the House together. In other ways, there are things that can be done to encourage people in these institutions to work together. And until we do that, if you're fine with things not getting done and you're happy with the status quo, then God bless, because it's going to be good for you. But if you want change, then these are the kinds of discussions that we have to be having. And they're hard discussions to have because they're structural and they're not incredibly sexy or exciting. But they are structural and they need to be had. So with that, I will stop talking, gratefully, for you. And if anybody has any questions, I am happy to take those. And obviously, thank you so much for having me, and thank you to Mr. and Mrs. Corbin and the League. Yeah, I don't know if you want.
Thank you for a very, very enlightening presentation, great history, and I think pretty good analysis of the law. This will be a question, but allow me please to put a preface. I think the complaint of division and partisanship is old. I think it's by our media largely overstated. I'm sympathetic to the ideas that you're presenting in terms of changing the law, welcoming new voters, evolving, having the Constitution live more than being dead letter, but not live every day. I think it shouldn't be changed daily. And we know that the last Constitutional Convention in New York State, to my knowledge, was defeated not by the forces of conservatism or reaction. To my understanding, was defeated largely by public employee unions. That's what I read. Another story entirely. I would just argue, however, that I think your discussion would be more complete if you made reference not only to the Civil Rights Act, which most Republicans like myself supported for the past 100 or so years, but also the 10th Amendment, which you know reserves some very important powers to the states. And I know the time doesn't permit it, but I was just wondering if you didn't think that some of the problems you cite that I could agree with as problems to progress, small p progress, and improvement in the lives of people, might be addressed by leaving those decisions to the states, which are, I know you say, is most important in the lives of people. I would say most people I know believe that the federal Congress is most important in their lives, mainly because of the media and our President Trump and the very well-known national political leaders. I'm just wondering if you think that leaving these decisions to the states might help address some of the anomalies you've cited that I think we all agree on.
Yeah, I mean, I think it depends on which decisions you're talking about. So in the context of voting rights, for instance, it has, when it has been up to the states, it has not gone the way that I personally, politically, would like it to go. But that doesn't mean the states can't do it. But I would like there to be some federal oversight of the voting rights. And I mean, I personally. But I could see other issues where I think that the states can absolutely do the business, and they do in this country. And you're right to point to the 10th Amendment. So I do think there is obviously an important role for the states. And I think in my mind it depends on which issues you're talking about. And obviously, as we think about the growth in federal power from the 1930s, reverting some of that power to the states has been a real call to action for many. I mean, you said you're a Republican, for many on your side. And I think there are arguments to be made depending on the issue. Yeah.
In terms of the voting rights of people in the country, as you pointed out, over the time of our country's history, they've been expanded. One area, and I'd be curious to see what your thoughts are, people who are in the country who are not citizens, but yet they are taxed. They pay property tax if they own homes and whatever else. Their children, if they are undocumented, are by the Texas Supreme Court, the case out of Texas years ago, have the right to be in our public schools, yet their parents are barred at the door from voting on the people who run their schools. And I'm just wondering whether you think the expansion of voting rights and the qualification of citizen in and of itself should be a requirement to vote, given the dynamic of our country, where in our communities so many people are here that are not citizens, but yet are full participants in our country's life. Do you believe that people who are here, whose children, say, go to our schools, should be allowed, say, to at least vote in our own community in school board elections as an expansion of voting rights? Or do you believe citizenship is the bar of the door?
I do think that citizenship, or, and this is just me, my personal opinion, and I would welcome a discussion on this. I do think that citizenship should be a citizenship, or some road to citizenship should be important when you're going to vote. I don't know how you expand voting beyond that. So when I say a road, if there was an avenue to citizenship open, or citizenship itself, in my mind, those two things would be important to be participating in voting at the federal level. Now, when you talk about voting at the state level or the local level, I would be open to more of a discussion on that, but I think in my mind, at the federal level at least, citizenship or an avenue to citizenship is in my mind important.
Well, I'm sorry. I don't
Yeah,
want
no, yeah.
But just to follow up on what Mr. Mayor was saying, to that end, his argument that perhaps leaving some of these questions of voting qualification to the states might serve well
Yeah.
in a state like New York, who might want to enact on a state or even a New Rochelle, or however we do it, to allow non-citizens to vote.
And that
I do
is,
believe in
yeah.
years past, in some communities, that was, and is, but if it's only gonna be controlled by the feds, then we would be
Yeah.
perhaps
And we
lost.
should say that in the Constitution, in Article, it is controlled at the state and local level. And that has been the battle, right, has been who should control those qualifications. That's where South Carolina was frustrated in the cats and bat case. So it absolutely, you could distinguish, and I would in my mind, between those two.
Could I tease one more thought, and I apologize? If we had a constitutional convention, perhaps we could settle the 14th Amendment argument and the other cases after that came with it about citizenship by birth. We are one of the only countries in the world that allows someone to claim birthright citizenship if none of your parents are a citizen of the country.
Yeah, and it's one of the things
And
that,
that might be an interesting discussion in and of itself.
yeah. Did you, yeah.
I wondered if you would comment on what I believe the League's, one of the current initiatives of the League to try to promote within the states a better way of drawing the congressional and legislative districts, and whether that has relevance to some of the issues you've been discussing.
Yeah, absolutely. I mean, I think when we look at one of the real problems in this country right now is gerrymandering and how these districts are drawn. I mean, in my mind, I think that and campaign finance reform are two of the key changes that we should be considering. And so, and you know, absolutely, the League has been at the forefront in this battle on gerrymandering, and rightly so. When we talk about an inability to get things done at both the state and the federal level, but whichever you look at, the way that these districts are drawn, so that you essentially have in some of these districts one-party districts, to me that is absolutely anathema to democracy. And I don't care if it's one-party Democratic districts like we get in so many parts of the city, or one-party Republican districts. You know, you can look at the South, you know, for so many years during Jim Crow, under the control of the Democrats, you win the primary and you are in. To me, that is anathema to how democracy should work, and much of that is driven by the challenge of gerrymandering. Now, how you correct for gerrymandering, and the courts have been talking about this and active in this, is a huge, huge question, because so many of the avenues that have been tried, the committees, the commissions, they, you know, may move the ball forward a little bit. In many cases, they don't move it forward as much, and so there's a lot of people out there working on that issue, but it's so important, that issue, gerrymandering. Yeah, and you, okay, I'll just do one question and then,
Constitutionally, war-making has been reserved for the legislative branch, but increasingly over the last 50, 60 years, the executive has been making more of those decisions. Do you see any way to remedy that or reverse that trend?
And I missed the first part. You said, the first part of it?
Constitutionally, war-making is
War-making,
reserved
okay.
for the legislature.
Yeah.
But increasingly over the last 2 generations, the executive has been grabbing that power. Is there any way that you see we could remedy that, reverse that trend?
I think Congress is going to have to step up. I mean, this is a case where Congress has sort of, again, abdicated its responsibility and been unwilling to challenge presidents, particularly in times of conflict, which is obviously hard to do. But I think one way is to get Congress, You know, in my mind, if the parties were stronger and the president was, listening to his party and in line with the party leaders in the Congress, you wouldn't have as much of that. So I think there are ways to diminish that. I don't know if you get rid of it completely, but I think you can diminish the problem. But it's going to take some structural changes, right? And I know we are short of time, so I'll let you go.
I want to make sure to be able to let the students. Yes, please join me in thanking Dr. Zaino as well as the Corbin family. She certainly helped us achieve our goals for this evening. Thank you so much. I think Dr. Zaino will probably stay around to answer a couple more of those questions, but we certainly want to let the students comfortably leave and head home. Thank you all, and good night.
My students, just put your name on one of the cards and give it to me.